Okay, well, hi, my name is Vivian Beaumont. I'm a policy analyst in the Colorado Office of Policy Research and Regulatory Reform and the administrator of the Regulatory Notice and Cost Benefit Analysis Program. Before we start, I would like to let you know that this presentation will be available as a recording, and we will also make slides and notes available to all participants. If you have any questions during the presentation, please do feel free to submit them using the written questions function. Brian Tobias, Copper's director, will respond to some of the questions during the presentation, and any questions that may be of interest to the entire group will be answered at the end of the presentation. If we don't get to your questions during the presentation, we will respond to you via email. However, if you don't hear from us in a reasonable amount of time, you're welcome to email your question directly to me, and my contact information will be provided through the chat function at the end of the presentation. Our office, Copper, has three main functions. First, we conduct sunset reviews of existing state programs or functions of government to determine whether regulation is necessary, and if it is necessary, whether any changes need to be made. Second, we conduct sunrise reviews to determine whether there's a need to create a new occupational or professional regulatory program. And third, as you know, we also administer the Regulatory Notice and Cost Benefit Analysis Program, which provides stakeholders the opportunity to receive notices of rulemaking and to request a cost benefit analysis of any proposed rules. I welcome the opportunity to talk to you about the Regulatory Notice and Cost Benefit Analysis Program and answer any questions you have. The purpose of this program is to ensure that state agencies consider the economic impact of the regulated community prior to adopting rules. This program is created under the Administrative Procedures Act, which, as you know, governs rulemaking in all state agencies. The statute that applies to the Regulatory Notice and Cost Benefit Analysis Program is located in Section 244103, paragraph 2.5 in the Colorado Revised Statutes. When an agency undertakes rulemaking, it is required to send notice to the Office of the Secretary of State and also to the Department of Regulatory Agencies, which is where we come in. Most of you already have an account with us, and for those of you who don't, it is easy to set up an account. You can find the web portal through Copper's website and click on the Files Rule button, or you can use the address on this slide. Then to set up an account, you simply select Request User ID up in the upper left corner. Once you've done that, you can fill out the form, create your own password, and then click on the Request User ID button at the bottom of the form to submit it. You will be emailed your user ID. If you lose your password, please do not recreate a user ID. Instead, you can select Password Finder, which is found on the login page directly above Request User ID, and your password will be emailed to you. Once you have a user ID and a password, you can file your rules through the same portal. When you click on Submit a New Rule, the system offers you a drop-down list of rulemaking agencies in your department, and it also allows you to enter a new rulemaking agency if it's not provided in the drop-down list. Please do not create multiple names for the same agency, because if you do that, then stakeholders who sign up to receive rules from one agency that is named may not be getting the rules that are being submitted by the rulemaking agency. While you can add the name of a new rulemaking agency to this list, you do not have the ability to make changes through this form to existing names. Sometimes these categories can change or become obsolete, and our office would not necessarily know if a rulemaking agency has changed its name or closed its doors unless you notify us. So please be sure to let me know if you find any outdated information in the drop-down list. For the most part, our office leaves it up to the rulemaking agency to determine the content of the rule filing. However, there are a couple of important things that we look for when the rule is filed. First, we're looking for the plain language statement about the subject matter or purpose of the proposed rule or the proposed amendments. Second, if the rule is being amended, we're looking for a strike-through or red line document that clearly shows what changes are being made. And if the rulemaking agency is adopting new rules, then we're simply looking for a document showing the proposed new rules. We do recommend that agencies submit the rulemaking document as a PDF rather than a Word document, but we will accept either. The plain language statement and the proposed rules are statutorily required, so if we find that one of these items is missing, we will reach out to you. Another thing that I'd like to mention is that the form requires two contacts to be entered, a private contact and a public contact. Most agencies enter two different contacts, but some agencies only enter one contact in both fields. We recommend including a backup person or a supervisor as the private contact in case there are problems with the filing or a cost-benefit analysis request comes in and we need to reach somebody at the agency. If you're on leave or if something unexpected happens to you, we will need to be able to reach another contact at the rulemaking agency who also has access to the rules and preferably is trained to use the system. If you need help filing the rules, one place that you can find it is by going to the login form and clicking on the help folder in the top left corner. The help folder will provide you with our email address so that you can reach out to one of us if you run into any problems. And it also provides you with a document that has detailed instructions about how to file rules using the online portal. Anyone may sign up to receive rulemaking notices from our office by filling out an online form that's available on our website. A stakeholder simply indicates a subject area or specifies an agency that they're interested in, and our office will automatically send them emails whenever rules they may be interested in are being proposed. The public may also find regulatory notices through the searchable database of proposed rules or through a calendar of rulemaking hearings, both of which may be found on our website. On this slide, you can see the sign-up form that stakeholders fill out to receive regulatory notices. You should note that the APA does require each rulemaking agency to post information about the cost-benefit analysis program on the agency's website with a link to this form. This form is also posted on COPR's website, so if you can't find the link or this presentation to find the link, then you can just go to COPR's website and the link is there to sign up to receive regulatory notices. Stakeholders can use this form to change their area of interest or to remove themselves from the registry, and they would just do that by clicking on this link at the top of the form. The rulemaking agencies on this form are the same ones that populate when you're filing rules with us. Typically, the name of the rulemaking agency already exists, such as the Air Quality Control Commission in CDPHE or the Accountancy Board in DORA. But sometimes rulemaking agencies do have to create new categories, and this would just be done when you're filing, when the rulemaking agency is filing its proposed rules with us. And then the new category that you create will automatically populate on this form. And here we have a screenshot of the searchable database. This is created for stakeholders to search rulemaking hearings throughout the state. It may also be useful to you in case you want to look for examples of how other rulemaking agencies file their rules, or if you want to look for examples of cost-benefit analyses. So when you get a request for a cost-benefit analysis, it may be helpful for you to look through and see how other agencies have conducted their CBAs in the past. If you're looking for CBAs that have been completed by your own agency or by your agency, this form allows you just to select only those rules with a cost-benefit analysis. And I do want to point out that you do not need to be registered as a user with the system to access the searchable database. So for those of you who are not registered users to submit rules, you don't necessarily have to register with us. You can just go to our website or to these addresses and see the searchable database. So on this slide, we have a screenshot of the rulemaking calendar that is available on our website. The rulemaking calendar is useful for the public to see when hearings are scheduled. If you click on the link in the calendar, it'll bring you to the detailed regulatory notice for the hearing. The calendar is one way that agencies can check their own filings. It may also be useful to you as it provides just another way for you to search for rulemaking hearings throughout the state, and it allows you to see filings by other agencies. Just like the searchable database, you do not need to be registered as a user with this system in order to access the rulemaking calendar. The regulatory notice that is emailed to stakeholders is automatically created by the system based on the information in the rule filing. An email notice, the email notice draws a few details from the information that you submit, and it includes it in the email. And this includes the department and agency names, the short title of the rules, the hearing date and location, and a plain language statement. And the email also includes an invitation to request a cost-benefit analysis at the bottom of the email. So here we have an example of the rulemaking notice that is was emailed to stakeholders. If you want to see how your own notices appear to stakeholders, one thing that you could do is you could sign up as a stakeholder to receive notices from your own agency. Sometimes the information is a bit confusing to stakeholders, so it's just a good idea to keep in mind how it will appear in the emailed notice. And that way you can, when you're filling out the, when you're submitting your rules, you can consider that and craft your notice in a way that makes, that's clear to stakeholders and makes sense. Here we have an example of the detailed rulemaking information that's available to stakeholders. Stakeholders can see this notice if they click on the link in the email or by using the searchable database or the rulemaking calendar. The detailed rulemaking notice includes all of the information about rulemaking that stakeholders need to participate in the process, including a link to the proposed rules. Again, all this information is entered by the rulemaking agency itself. It's just important for you to think about how this information is being presented to stakeholders when you're putting it into the system. Both the email notice and the detailed rulemaking information offer stakeholders the option of requesting a cost-benefit analysis. Anyone may request that an agency conduct a cost-benefit analysis. A request for a CBA must be filed with our office no later than 5 days after the rulemaking notice is published in the Colorado Register. When a stakeholder sends a CBA request to our office, we will immediately reach out to the rulemaking agency to determine whether one should be required. We do require a written response from the agency. The presumption is that a cost-benefit analysis will be required unless any of the exemptions apply. If a CBA is required, it will be due 10 days prior to the scheduled hearing. And if the rulemaking agency needs additional time to complete the CBA, the statute does allow rulemaking agencies to delay the hearing. So if a rulemaking agency delayed the hearing, if it was originally scheduled for November 1st, it would be due 10 days prior to that. If you delay the hearing to December 1st, then the cost-benefit analysis would be due 10 days prior to December 1st. So if your agency does delay or cancel a hearing, it is important to let us know. That way we can send out notification to stakeholders. And it's especially important to let us know when a CBA is pending, because that information is in the system, and we need to know, if it's not, when the cost-benefit analysis is actually due. There's only one exemption that is provided for in statute, and in my experience, it rarely applies. The statutory exemption is if the rule concerns orders, licenses, permits, adjudication, or rules that affect the direct reimbursement of vendors or providers with state funds. For practical reasons, Copper has developed 3 additional exemptions that we've adopted by policy. The first exemption is if the rule or the amendment mirrors federal or state law. And the second exemption, is if the agency lacks discretion about the substance of the rule. And then the third exemption that we created in policy is if the rule in question is neither new nor being amended. So I'll talk a little bit about each one of these exemptions that we created in policy. If the rule or the amendment mirrors federal or state law, so basically there already is a requirement in federal or state law, and it's just being reflected in your own rules. For example, you have to drive on the right side of the street. If you include that in your rules, then a cost-benefit analysis wouldn't be appropriate because that requirement already exists. So the second one is if the agency lacks discretion about the substance of the rule. So that is just the, in case there is a requirement, say there's an administrative requirement through a federal agency to submit a certain application by a date certain, then if you put that into your rules, a cost-benefit analysis wouldn't necessarily be appropriate. The third exemption that we created in policy is if the rule in question is neither new nor being amended. So that's a little confusing because obviously you have amendments in your that are being proposed, and what we mean is rulemaking agencies sometimes go through their rules and clean them up. You may have different spelling conventions, or you may have some punctuation errors. Perhaps certain terms are capitalized sometimes and not capitalized other times. Or another example is sometimes rules get sort of just put in, and after a while the order doesn't really make sense, it doesn't flow, it's hard to find things, and if rulemaking agencies are just moving things around so that it's easier to find the rules and easier to follow them, as long as the rulemaking agency isn't actually changing the substance of the rules, in those sorts of cases we would say that the amendments would be exempt from a cost-benefit analysis. If a cost-benefit analysis is required, then the APA asks rulemaking agencies to consider the following: the reason for the rule or the amendment, any anticipated economic benefits, including economic growth, the creation of new jobs, and increased economic competitiveness, any anticipated costs, and the APA does require agencies to consider not only the cost to the regulated community, but also the cost to the agency itself. So any administrative overhead that may be generated by adopting the rule. And then also, the agency is required to consider any adverse effects on the economy, consumers, private markets, small businesses, job creation, and economic competitiveness. And then the one question that sometimes causes the most heartburn with agencies is the requirement to consider two alternatives and the costs and benefits associated with each alternative. So this seems pretty straightforward, and for a lot of rulemaking agencies it is, because they've already considered other alternatives when they were considering, first considering changing the rules, and so they can easily put those alternatives into the cost benefit analysis and include the costs and benefits associated with each. That's not a problem, but depending on the rule, sometimes alternatives to the rule are not readily apparent, or they just practically don't exist. So one thing that we have seen rulemaking agencies do to address this is one alternative could be not adopting the rule or the amendments to the rule. So that could be one alternative that you may include in your cost benefit analysis. And then typically rulemaking agencies can come up with another alternative. Sometimes, just depending on the rule, it can be a little bit contrived, and that's too bad, but the APA does require that. So when you are when you're constructing your cost benefit analysis, it is a requirement, and we do look for that when we're looking to see if a cost benefit analysis is complete. So when we determine that a cost benefit analysis is required, you will be sent an email with a blank CBA form. Please use this form when you complete the CBA. The CBA should be submitted through the online portal, so someone who has access to the rules will need to be available to submit the CBA. You should also keep in mind that the portal will only allow one document to be submitted for the cost benefit analysis, so any exhibits or attachments do need to be compiled into one document. We recommend that agencies file a PDF rather than Word, but again, we will accept either. Typically, agencies submit the CBA as a PDF document. When a CBA is submitted, we will review it to make sure that it is complete. At the end of the day, the rulemaking agency is the subject matter expert, so we leave it up to the agency to determine what to include in the cost benefit analysis. However, the agency must make a good faith effort to answer all the questions laid out in 24.103 2.5. And it is important to remember that the rulemaking agency must also post the completed cost benefit analysis on its own website. I do recommend that agencies wait until we have reviewed it for completeness and have made that cost benefit analysis public before they post it on their website. But that's only so that, if they do need to revise the cost benefit analysis before we make it public, then there isn't another cost benefit analysis that's floating out there that stakeholders have already seen. So that's just something to keep in mind. You may not, the rulemaking agency may not necessarily have any control over when you who are filing the rules may not have any control over when the hearing is calendared. However, if you do, we recommend building in some time in between when the rule is published in the Colorado Register and when the hearing is scheduled. According to statute, a CBA may be requested 5 days after it's published in the Colorado Register, and then it's due 10 days prior to the scheduled hearing. So ideally, you would build in sufficient time in between the rule being published and 10 days prior to the hearing date in case the CBA must be completed. Sometimes we just see that, that there's a very narrow window of time there for cost benefit analyses to be completed, and depending on the complexity of the rule, this can cause problems. And we really don't want to see agencies having to delay rulemaking in order to complete the cost benefit analysis. Another thing that you may want to consider is filing each rule separately. So you may have one rulemaking hearing with multiple rules that are being considered. So take, for example, if you submit 5 rules in one filing, a stakeholder could request a cost benefit analysis on all 5 rules and refuse to provide any clarification on which one of the rules is truly of concern. And we don't really have a lot of leeway there. If the exemptions don't apply, then we would have to require a cost benefit analysis on all 5 rules. So this is less likely to happen if you file each rule separately. Then you get a little bit more clarity about which rule is concerned if a cost benefit analysis is requested. It may take more time to file your rules on the front end, but it could save your agency a lot of time and effort in case the CBA is requested. Now, I understand that that's not always going to be possible for rulemaking agencies, and a lot depends on the rules that are being filed. But it's just something to keep in mind when you're filing your rules with us. So it does look like we are at the end of the presentation. Are there any questions that I can respond to?
Hi, Vivian. Hello, everybody. This is Brian Tobias. Vivian, we only got one question in the question function, and I was able to answer that. It was not really appropriate for the entire group. So I would say if nobody else has any questions, let's go ahead and put your contact info in the chat. I'll do that right now, and then we can sign off. So thanks, everyone, for joining this morning.
Oh, Brian, it looks like we do have a couple questions that have just come in.
I'm not seeing them, so could you help me out there?
Okay. Please? Yep, let me go ahead and read those for you. So the first one is, can you explain the difference between a regulatory analysis and cost benefit analysis?
I'm going to punt that to Brian. Brian, can you respond to that?
Unfortunately, I really can't. It's a great question, though. We're really only focused on the cost benefit analysis process in our office. I know the regulatory analysis process is out there, but we don't really have any involvement with that. So I really don't feel qualified to be able to explain the distinction between the two. And I apologize for that.
That may be a question that you can run by the Attorney General that you work with. Are there any other questions?
Yeah, there's another one, which is, where would we find this recorded webinar for future reference?
I believe it's going to be posted on COPR's website. So if you go to coprrr.colorado.gov, which is just on this slide, then it will be posted under the rules section of that website.
Yes, that's correct, Vivian. So, and again, another question was, what is the COPR website? So COPR, for everybody's benefit, is the abbreviation we use for Colorado Office of Policy Research and Regulatory Reform. So again, go to that website, coprrr.colorado.gov, and under the CBA section, this will be posted. Another one for you, Vivian and Brian, is, can you expand upon local government process?
I'm not sure what the question actually is. This is a process for state agencies. I don't know what the process is for local governments, if there is even anything similar to this.
For the individual who submitted that question, if you want to go back into the question function and clarify, if that would be helpful. That would be great. Okay, and just in case you're not seeing it in the chat function, additional email questions can be submitted to Vivian at vivienne.belmont@state.co.us. I have just one more question while we still have some time. Is there a separate feedback or comment period required? Oh, and that is also, I think this is from the individual who submitted about local governments. They stated for rules for state agencies that apply to local governments, is there a separate feedback or comment period required?
Not that I'm aware of. The CBA process just fits within the normal rulemaking process. So, you know, local governments can, and I think they have in the past, requested CBAs be performed. So local governments are a stakeholder just like anybody else, and anyone can request a CBA. The only timelines I'm familiar with are, you know, the 5 days, CBA has to be requested within 5 days of publication in the register. And then if a CBA is required, it must be produced 10 days before the hearing. So, you know, unless the agency has some other mechanism to receive, you know, feedback and comments during its regular rulemaking process, that's really the extent to which we're involved. Whether those rules involve local governments or anything else.
Yeah, we can't speak to the whole rulemaking process because there's much more involved. There's other timelines and other requirements, like the regulatory analysis, and we can't speak to that. We're not experts on rulemaking in the state of Colorado. We only facilitate the regulatory notice and the cost-benefit analysis process, which is just a small part of that.
Great, thanks guys. Another question has come in. How long can a regulatory hearing be delayed to complete a CBA?
The statute doesn't specify. So, you know, as long as you need to take to complete it, I think we've had some delayed as long as a couple months, haven't we, Vivian?
Yes. Yeah, I don't think that it's been any longer than that, but usually a month or two.
Great. And then a final one, is there a copy of the slideshow available?
We will make a copy, we will provide copies to all of the attendees. Is that right, Jill? I think we can do that.
Yes, that's correct. So there will be a follow-up email sent to everyone who attended that we can include a copy of the slideshow.
Right. Okay, so we'll do that, and then the presentation, the recorded presentation, will be on our website. Are there any other questions?
Okay, it looks like that is everything.
Great. Well, thank you so much, Jill, and thanks, Brian. And thanks to all of the attendees for taking time out of your day for this presentation. I do hope it provided some useful information, and I just want you to know that we would welcome any comments that you have about how we could improve the regulatory notice and cost-benefit analysis program. So please feel free to send any additional questions or comments directly to me via email at vivian.belmont@state.co.us. My contact information is listed in the chat area. You can also reach me through the email address that's listed on this slide. Again, thank you so much for taking time out of your day to attend the presentation. And please contact me if you need any assistance with filing rules or with the cost-benefit analysis process.
Wonderful. Thanks, everyone.
Great, thank you.